You are live now. Start.
Wish everyone a very warm evening. Hope you all are doing fine in this situation. Well, this is the situation where we, the students, are unable to attend our classes, seminars, lectures, and whatnot. So, by considering all these aspects, Team Dhyan has taken an initiative to conduct online lectures and webinars. It is the fourth session of the series, and today's topic is electronic evidence, mode of proof, and importance of Section 65B of Indian Evidence Act, which will be delivered by Dr. Pratyusha Das. Dr. Pratyusha Das, who is proficient in both civil and criminal law, is at present an assistant professor of Amity University-Kolkata. Earlier, she was in Kalinga Institute of Industrial Technology, KIIT Bhubaneswar. Dr. Das is an excellent professor, scholar, and also an author. She has written a book entitled Forensic Evidence Admissibility in Criminal Justice System, which is published by Eastern Law House, India. It mainly focuses on the kinds of forensic evidence that is collected at the crime scene and implication of forensic evidence in the court of law. And the rest of it, let's hear it out from the author herself. We welcome you, ma'am, and it's all over to you now.
Thank you, Shreya, and a very good evening to one and all present in this webinar. And I would like to acknowledge and thank Dhyan for their wonderful initiative of doing this for the students. Okay, when all are sitting at their homes and they want to enhance their knowledge, this is the right time and an opportunity for doing that. So really, it's a wonderful initiative on your part. So today, the topic is electronic evidence and its mode of proof, and also a very critical discussion on Section 65B, because the electronic evidence and its admissibility is dependent on this Section 65B of the Indian Evidence Act. Now, before I start with this lecture, let me tell you and give you an understanding with what is Section 65B, and also before that, what is basically electronic evidence. Now, let me tell you, students, when electronic evidence we talk about it, firstly, the concept of evidence has to be very clear. Now, it is in many minds that evidence means proof, but evidence is not a proof. Rather, I would tell you, if you go to Section 3 of the Indian Evidence Act, you would find there are certain statements made by the witnesses and also certain documents which are produced before the court. So evidence basically means documentary evidence and also oral evidence. Now, whenever we talk about electronic evidence, you can understand this is basically a form or a different type of documentary evidence. Now, here we have to see what is electronic evidence. Now, of course, hope all of you have an understanding now of what is evidence. Now, let me give you an understanding of what is electronic evidence. Now, electronic evidence, if you talk about electronic, okay, it is basically certain information which are stored in electronic media and which are also produced from such kind of electronic media. It might be a computer, might be a mobile phone. So there information stored and transmitted in digital form and which is used in the court, okay, for any trial, for any other means, maybe a civil matter or maybe a criminal matter. So anything which is stored in a digital media or maybe any electronic form and also transmitted through that is known as electronic evidence. Now, of course, we are going to see the speciality of this evidence. Now, how it is different from other evidences, because normally we deal with paper-based evidence. So why electronic evidence is dealt differently than any other paper-based evidence? Now, that is a very crucial issue at this point of time. So the thing that we have to consider is why it is so important now, and what are the similarities of electronic evidence with other evidences. Now, if we compare it with paper-based evidence, we'll find that, electronic evidence is such, it is susceptible to changes very soon. So it can be tampered, it can be changed, It can be changed at any instant. It is not required for any kind of formalities also to change those evidences. So we have certain data in a computer. If it is before us and we know the password, we can enter into it and change the data. So this is a very crucial means where it is very difficult for the court to ascertain what has to be done or how to take this evidence. What is the authenticity of this evidence? That is very much required. Now, let me tell you that since this evidence is very crucial, or this authenticity of this evidence is always in question, the courts have introduced various modes to test this evidence. So basically, these are the two modes, or you can say authenticity and the storage of this evidence is very much essential. So authenticity means from where it's coming, how it's coming, and also how and where it was stored. Now, let me tell you the similarities of this evidence with other evidences. Now, the basic thing, or a basic criteria of any evidence is the test of relevancy and admissibility. Now, whenever we talk about relevant evidence, what is the term relevant? Relevant means the connectivity of that evidence with the facts in issue. Like if there is a case going on, which is a murder case, A is the fact in issue is whether A has murdered B. So something might be relevant which has a connection with this case, like A was a very good friend of B, or maybe that they were enemies to each other. So there are certain connectivities which make the facts relevant. Similarly, the same way, the relevancy criteria is applicable for electronic evidence also. But in case of admissibility, the criteria is a bit different, because here where the electronic evidence stands on a different footing than other evidences. Now, what is it? Now, basically, before I start before I say what it is, let me tell you what is admissibility. Now, admissibility means how the court is accepting, or the acceptability of that evidence. Now, let me give you a simple example to make you understand. Like, suppose if I take a sale deed is in question, whether the sale deed is really authentic or not. Now, maybe the document, maybe I can have, or I may be possessing a photocopy of the sale deed. Now, I present the sale deed or the photocopy of the sale deed before the court, where I do not possess the original with me. Now, the photocopy is of course relevant because it is connected with the sale deed, and it is the same sale deed which I, or the original person who is having or possessing the original sale deed would have. So the photocopy is having the same thing, or maybe the same contents as the original sale deed. But the question is that whether this photocopy is admissible in the court. The answer would be no, because this is not admissible, because a photocopy has no relevancy in the sense that it cannot be accepted. It may be tainted, or maybe there is some problem. So according to section 65, a photocopy is not accepted even as a secondary evidence. What may be accepted is certified copy. So hope you can understand the meaning of what is admissibility, because admissibility means something which is the acceptability criteria of any evidence. Similarly, in case of electronic evidence also, there are certain criteria which makes the evidence acceptable, or maybe it is rejected. Now, so these two criteria of relevancy and admissibility are very much important, even if we talk about the electronic evidence. Now, let us see, after this, there are certain other grounds on which an evidence may be accepted in a court of law. They are reliability, authenticity, completeness, and believability. But these things, of course, depends on the two basic criteria of relevancy and admissibility. So I think this is very much clear that when an evidence is admissible and relevant, the evidence is believable, or maybe in certain criteria it might not be believable. But the first criteria which has to be satisfied is whether the evidence is relevant or admissible and admissible. So let us see what is the nature of electronic evidence. As I told you earlier also, electronic evidence are susceptible to changes, and they're very fragile, they can be altered, and they're very sensitive. And the purpose of making this evidence an important one, because it is the reality, or maybe that it is the susceptibility of this evidence where it can be tampered. So this is what is the reason why this evidence has to be looked into from a different aspect, or from a different side, or maybe from a different legal point. Now, after this, we come up to one more very important criteria is rule of hearsay. Now, what is a rule of hearsay? Firstly, let me tell you that the Indian Evidence Act says that hearsay evidence is not admissible because it is a secondary evidence, not even secondary, it has no value at all in the eye of law. The reason is that when a hearsay evidence is placed before a court, its authenticity is always in question. So hearsay means something which is not reliable and which comes from a different source, which is not a direct one, or rather it is an indirect evidence. So the question is that when anything is stored in an electronic media, maybe it's a computer or maybe it's a telephone, of course, or maybe a cell phone or maybe some other devices, the stored data cannot be taken directly before the court unless we bring it out through a document. We can get a printout of those or maybe a certificate from that through which we can go for the trial, or maybe we can produce that in the court. So when you produce that information before the court, it is not a first-hand information. It becomes a second-hand information because all that is stored is in the computer, and it is not possible for us or to anyone, for anyone to take the computer and or maybe the device or maybe the cloud where it is stored. So what we can show before the court is just a document which we get out and it is transmitted. So we put that document before the court as evidence. Now question is that when we put that document, it is not the primary evidence or maybe it is not the original one, because the original one is stored in the electronic device. So the question is that shall we take or shall the court take this as an evidence or not, or shall this evidence be admissible in the court or not? Now regarding this, we have different judgments of court, and if we see even foreign courts, there also the idea or the viewpoints of the courts doesn't differ. They are on the similar base that these evidences are so important that they are regarded like the original one. Now I give you certain cases, I refer certain cases where the court has actually confirmed that this evidence have the characteristics like the original one, and the court will be taking these evidences as the original one. Now, I would refer a case of US Bonallo 2002, where the court had said that a data content in a computer is plainly insufficient to establish its unworthiness. So, at the prima facie, if some data comes to me and I say it is unworthy, it cannot be taken by the court unless I give a better proof that this is something which is unworthy. So even if a data is produced before the court, there is no reason for the court to disbelieve the data unless this question comes before the court that it is something which is unworthy of credit. So this is what the case talks about, which is a 2002 case. Another case of the different jurisdiction which I'm going to tell you is Agumatang versus California State Lottery, where the Honorable Court observed that computer printouts does not violate the basic or the best evidence rule and are considered as original. So you can understand, so whenever a computer printout is taken out, it is regarded as an original one. So there is no question or no uncertainty regarding this. Another case I would like to refer here is State of Armstead. The court refused to hold digital evidence as hearsay. So here in this case, the court directly said that digital evidence is not a hearsay one. So from this pronouncements, we can very much understand that any evidence or any electronic evidence which is placed before the court, at prima facie, it cannot be said that it is disbelieved or it cannot be taken as an evidence because it has value until that is questioned. So these are, and it is always taken as an original evidence. Now, before we come to the Indian Evidence Act, let us think of the other laws which are also relevant in this regard. Now, before 2000, we had electronic evidence, but maybe it was not so formal. But the understanding of electronic evidence has been made formal through the coming up of the IT Act in 2000. And the preamble of the IT Act recognizes this electronic evidence. So it's a very important legislation for us where electronic evidence has been recognized. Before that, it might be in the courts, but it is not formally recognized. So that is why
জিওগ্রাফির লেকচার
electronic evidence are very much essential in this regard, because IT Act shows us the way how to follow and how to accept it, whether this is really acceptable or not by the courts. The second one, we would refer to Section 4 of the IT Act, which confers a legal recognition to electronic records. So Section 4 of the IT Act also gives it a recognition, which is very important for the purpose of understanding of the evidence or electronic evidence. After this comes Section 6, where documents when required to be written for a specific purpose and it is written in an electronic form, it is taken to be something which is genuine. So these are some of the provisions of IT Act which very well or clearly specifies that electronic evidence is something which has to be recognized by the courts, and it has a lot of probative value. So after this, and in conformity with the IT Act, the Indian Evidence Act also has been amended, and the incorporation of Section 65A and Section 65B has been made. But before that, the word electronic evidence has also been incorporated in Section 3 as an understanding of what is evidence. And in that, the inclusion of this word has been made, because evidence also includes electronic evidence. And then if we come to Section 65, of course, there are many other sections. If you read the Indian Evidence Act, you will find there are many other sections which actually portray this, that the importance of electronic evidence is very well recognized. But at the instance of Section 65A and 65B, we can say that the modes of proof of electronic evidence are a bit different from any other evidences. Now, if we go to this, firstly, we would refer to Section 65A, which very clearly says that the provisions of how to prove the evidence or the electronic evidence has been laid down under Section 65B. Now, 65B is the crux, or it actually gives us the way of how to prove an electronic evidence. So that is what very important for us. Now, as I told you earlier also, for electronic evidence, two things are very, very important. They're the source and the authenticity of the evidence. Source and authenticity are very much important. And if we come to Section 65B, we will have the same understanding, which says that any document can be regarded as electronic, or it is something which is produced from an electronic record, and it would be recognized by the court if certain criteria are fulfilled. So we can divide the criteria into 4 points, where we can see how it is recognized or what is the criteria of admissibility. As I was telling you, that any document or any electronic evidence has to be admissible first. So the criteria for admissibility has been given under Section 65B. So the first criteria says that any information which was produced during the regular course of activities by the person having a lawful control over the computer's use. So the first criteria is that it has to be seen or ascertained by the court whether the electronic evidence which is produced was produced during the regular course of activities which was taking place in the office or maybe in the business. So the regular course of activities are very much important to prove. It is not that, for the purpose of evidence, certain things are fed into the computer and that is brought out suddenly and placed before the court. So it has to be a normal way where, in the regular course of business, the informations are put in the computer or they're produced from the computer. That is very important. The second thing which is required in this section or under this section is it has to be regular fed into the computer in the ordinary course of the said activities. That means the information that is produced or through the electronic mode, the information which has been gathered, it has been fed into the computer. It has been put into the computer. Unless it is fed, it cannot be taken out from the computer. but it has to be fed not suddenly but through the regular course of business or activities. So it should be a regular business where it is continuously fed. Like in registry offices, suppose you want to produce a document before a court, and in the electronic form, or it is something which is a printout, of course you have to show that it is produced from the registry office or the register of assurance, where they actually feed it in the course of their work. Every registration that takes place are actually incorporated or they're fed into the computer system. So it cannot be questioned then that it is fed in the regular course of the activity. And the second thing, which is I told you, it has to be produced through that regular course. The third one is that the computer was properly operating, because it can be such that a computer is destroyed, or maybe it was not workable, or the condition was not proper, or anything which has been fed is lost. If that is the situation, then the evidence is not believable. But if certainly, even if it is not in a proper situation or it is not properly working, but it has to be proved before the court that even if there was certain improper operation or there were certain problems in the media, but that did not affect the electronic record. So that its accuracy is also affected. So what has to be proved or placed before the court is that if certain things, if it is from a computer, the computer was in a proper manner working in a workable condition. And if it was not in a workable condition, in such case what would happen, it would be shown that maybe it was not in a workable condition, but in that way it has to be ascertained that the documents or anything which was fed into the computer are accurate and it did not hamper any kind of information which was in the computer. So this has to be proved. And the fourth one is that derived, and this information what I was stating, any information which has been fed, which has been produced, and which has been derived from a computer, okay, has this information has been fed in the ordinary course of business which I was telling. So it has to be in a regular way. It is not that suddenly some information is fed in the computer and that is produced before the court. So if this four criteria is satisfied, then according to section 65B, any information or any electronic record may be produced and that will be believed by the court. One more point is very important in this regard, which section 65B also says that it is not only that somebody states that this is from a computer which was used in the regular course of the business, or this was fed, the informations were fed in the regular course of the business, or we derived the information from the regular course of the business. Only that is not important, but with that there has to be a certificate. And who would issue the certificate? An officer in charge of the operation or management of the related activities. So it is not that anyone would produce a certificate confirming that the electronic record is authentic, but it should be a person who is actually dealing with that information regularly and actually dealing with those activities, and he was a head or maybe a person who was responsible for the operation and management of that activity. So a person who is responsible for operating or managing such kind of activities, a certificate has to be produced from such officer before the court. So this is the criteria. So if we divide section 65B, these are the criteria which are required. If these are produced or this can be proved before the court, then any electronic evidence will be admissible. After this, what is important? So this is what is required in case of section 65B, or how to prove section 65B. Now, if we see a combined effect, if we see a combined effect of both IT Act and the Indian Evidence Act, we will find that whatever we are studying, or all the incorporations which have been made, the straining of this electronic evidence is basically for one purpose, that is sanctity of the evidence, the authenticity of the evidence. These are only tests to prove the sanctity of the evidence. If the sanctity of the evidence is not there, then of course the evidence would not be believable. And even if it is admissible, then it cannot be taken or cannot be believed by the court. So only the reason why this is required is the sanctity of the evidence. And if we see, there are different images, text, and sound videos as of now, if we talk about even recordings, video recordings, or even sound videos, they are falling or they come within the purview of this electronic evidence, and they're all very, very relevant in today's context, especially when we are talking about the virtual world. The virtual world would work only with electronic evidence because there are no other means. You cannot place a document before the court. You can scan a copy and you have to produce it before the court. Then coming to the effect of certain kind of judgments which are very relevant to this electronic evidence or very relevant to the discussion that we made. Now, all of you are aware of the Ajmal Kasab case of 2012. Now, in this case also, this electronic evidence was a very important or played a very important role in proving the matter or for the prosecution. It was the production of the transcript of internet transactions. All the transactions that had taken place, the internet transcript has been produced before the court to prove the transactions and the links between the terrorist act. So this is very important, and this case was one of the very important examples where we can show how electronic evidence can help. Secondly, one more very important case which has come up is the case of NCT of Delhi versus Navjot Sandhu, that is 2005 case, which is this is also a terrorism case where there was a link found between the slain terrorist and the masterminds of the attack, and this link was actually established from the phone call transcripts which were obtained from the mobile service providers. So from the mobile service providers, these transcripts were collected, which were produced before the court, and basing on that, it was very much easy for the prosecution to get hold of the masterminds who were involved in this crime. So we can understand the importance of this kind of evidence. Now, lastly, I would like to say that the amendment of the electronic evidence has come from 2000 because the IT Act was brought or it has come into force in 2000, and you can also find out Section 65, which we have just talked about. But all these amendments or these changes have been brought about, which is based on the United Nations Commission on International Trade Law, that is UNCITRAL Model Law on Electronic Commerce. So basically, this changes incorporated in the nations, and it was allowed in 2000 to understand, and these amendments also had an effect on the Indian Penal Code and also the Bankers Book Evidence Act 1891. So this is very much relevant. And lastly, I would also talk about one more important case, which is also very important. That is the case of Afzal Guru, or you can say this mastermind case which I talked about. Or another case I would talk about, Anwar PV versus PK Bashir. This is a case of 2004 where the Supreme Court of India observed that electronic evidence are relevant and they're admissible evidence. This is very, very important case because all the criteria, even in this case, it has been reiterated by the Supreme Court that Section 65B is the only mode through which electronic evidence may be proved. There are no other modes. So only if we satisfy the criteria that is based or that is fixed under Section 65B, then only we can take electronic evidence and those would be admissible in the court of law. So this is all that is about electronic evidence. It has other facets also that may be discussed later. Thank you so much, students.
Wow, what a session it was, ma'am. Thank you so much for such a wonderful lecture and for your valuable time. We would surely like to see you again with us as a speaker for our upcoming sessions. I would also like to give a big thanks to our esteemed viewers for staying with us for so long. It's a humble request from our end to like, share and subscribe to our channel, and definitely hit the bell icon button to get notifications for our upcoming sessions. There is an update. We are going to have our next session, that is on 21st July, Tuesday, sharp at 7 p.m. And the topic will be Introduction to Corporate Law, is delivered by Astha Kumari. So please stay with us. Thank you so much, everyone, for being with us.